Well, thank you so much. Good to see everyone. We are in our third panel on markets. We have three very interesting papers. I will briefly introduce our writers in, alphabetical order as opposed to the order they'll actually be presenting in. So first, Naomi Lamoreaux, who actually has co-written a paper with Rebecca Eisenberg, who unfortunately couldn't be here. Naomi Lamoreaux is the Stanley B. Resor Professor Emeritus of Economics and Professor Emeritus History at Yale University, Senior Research Scholar at the University of Michigan Law School, and a Research Associate at the National Bureau of Economic Research. She received her PhD in History from Hopkins in '79 and taught at Brown, UCLA, and Yale. She's written The Great Merger Movement in American Business, 1895 to 1904, and Insider Lending, Banks, Personal Connections, and Economic Development in Industrial New England, edited 9 other books, and published numerous articles on business, economic, and financial history. Her current research includes business organizational forms and contractual freedom in the US and Europe in the 19th and 20th centuries, the public-private distinction in US history, state constitutional changes mandating general laws in the 19th century US, and as we'll hear a bit about today, the US Patent Office as a site of learning in the administrative state. I'll just briefly mention her co-author, who couldn't be here. Rebecca Eisenberg is the Robert and Barbara Luciano Professor of Law at the University of Michigan, where she specializes in patent law and the regulation of biopharmaceutical innovation. She's written and lectured extensively about the role of intellectual property in biopharmaceutical research, publishing and leading law reviews in scientific journals, and she's played an active role in public policy debates concerning the role of intellectual property in biopharmaceutical research, advising the National Institutes of Health and the National Academies of Science. Jared Lucky, who is very modest and gave me too short a thing to read, so there's more to be said, but we will keep with his modesty. Jared Lucky is a PhD candidate in history at Yale, and he received his JD from Stanford Law in 2023, and he is currently completing a dissertation on the colonial origins of American consumer protection law, which we will hear a bit about today. And then, last but not least, Laura Phillips Sawyer is the Jane W. Wilson Associate Professor of Business Law at the University of Georgia Law School, where she teaches antitrust. She also holds courtesy appointments in Georgia's Departments of Economics and History, and she was previously an assistant professor at the Harvard Business School. She holds a PhD in history from the University of Virginia, and her book, American Fair Trade, Proprietary Capitalism, Corporatism, and the New Competition, 1890 to 1940, was published by Cambridge in 2018. Her work has been published in Business History Review, Law and History Review, co-authoring, I was learning, with Naomi Lamoreaux, University of Chicago Law Review, and a bunch of other journals as well. So thank you. That
Thank you very much for that, Amalia, and to all the organizers of our event who tolerated my perpetually tardy submissions. Thanks so much to Doris and Giselle and Maria and everybody else who's got this wonderful event. So, can you hear me? How about now? Better? Great. So today, as Amalia mentioned, I'm presenting a portion of my dissertation research entitled The Imperial Origins of American Consumer Protection Law. And when I say consumer protection, the thing that may come to mind, this gentleman, for the Gen Z members of the audience, that's Ralph Nader. And that wouldn't be a crazy thing to think, because Ralph Nader is very closely associated with many of the statutes that provide the bulk of modern consumer protection enforcement. And those statutes are very representative examples of what Sean Faring has called the litigation state. That is, our regulatory framework in the United States that really puts a heavy emphasis on private enforcement, where private individuals bring suits authorized by statute to vindicate consumer rights, antitrust cases, civil rights, environmental law cases, and many other areas, with regulatory agencies playing some supervisory role, but in a very limited capacity by bringing their own litigation or through rulemaking. And I think the other distinctive feature of American consumer protection law is what you might call a dual mission. There's both an ethical goal of consumer protection law. Obviously, it is trying to punish frauds and deceits, but there's also a developmental or an economic goal that I think is very distinctive. The goal of consumer protection law is to facilitate trust in products, in transactions, and to effect a net increase in prosperity. And that's very neatly symbolized, I think, by the FTC seal there that's got the scales for justice, obviously, and the winged wheel for commerce and progress. To step away from law for a second and into history, consumers and consumption are quite a big topic of historical inquiry these days. And that's true even in the early modern period and in the 18th century when I'm working. But there are quite a few different ways to tell that story. And Lawrence Glickman gives a helpful typology of three of the prominent narratives that historians have used to understand consumption and consumers. Obviously, there are material histories exploring kind of the rich goods that circulated in the early modern world. These Dutch still lifes are always appear on the cover of those books. And of attempts to emulate the higher classes. That's often a subject of books on Josiah Wedgwood's famous pottery. But when it comes to consumers, there are three buckets you can put consumer history in. First are histories of consumer activists. So this would be boycotts. A classic example is Americans refusing to drink tea during the American Revolution. That's been unpacked quite extensively. Another category is the organized consumer movement itself. And that's more getting into the territory of Ralph Nader and the FTC and the materials on my previous slide. And it's mainly a 20th century story, understandably so. But the category that I'm more interested in today is what Lawrence Glickman calls the consumer regime. And you could define that as the legal relations underlying consumption. And a great example, also Glickman's of this, is McDonald's. It's an iconic emblem of American consumption. But if you really want to understand McDonald's, you have to understand the interstate highway system that was created to put people out on the roads, that created the need for standardized fast food across a broad sweep of the landscape. And consumer protection law is obviously a big part of the consumer regime. But as I mentioned, the historiography of consumer protection is very focused on the 20th century. And if you've been to law school, you probably learned that before the 20th century, we lived in a buyer beware world. There were not many remedies for consumers who had found themselves on the bad end of a deal. And the inquiry pretty much ends there. It's assumed to be a story of the more complex and global economy of the 20th century. And that's understandable, but I'm going to challenge that paradigm a little bit today with a case study of the colony and later the province of Massachusetts Bay from about 1692 to the beginning of the 19th century, looking particularly at the legislative activity of the provincial assembly. And I think that there are a number of overlooked regulatory efforts in the early modern Atlantic world, but particularly here in colonial Massachusetts, that correspond to like a meaningful definition of what consumer protective law is. And today I've pulled out three of those categories, which I've given the annoying alliterative designations of bread, barrels, and borrowing. So to begin with bread, and I should say that what unites these categories in the lawmaking around them in the 18th century is first a shared vocabulary. You see colonial legislatures using terms that would be very at home in the modern FTC, preventing frauds and deceits. That's kind of a watchword. In a somewhat more antiquated term that they use is oppression, not in the political sense, interestingly, but in terms of economic oppression, of oppressing your neighbor through a bad bargain, which has resonances in the Bible and the Old Testament. But there's also a similar institutional structure in both inspection and in court enforcement, namely these laws have a striking degree of private enforcement. So I think the most obvious area of consumer protective legislation in early British America concerns bread. Starting with grain, which was an essential commodity and one that was very prone to being monopolized by millers who had control of the grain supply in an area. So throughout the colonial period and well into the 19th century, the Massachusetts legislature is passing pricing restrictions on grain, in other words, limiting the toll or the percent of the grain that a miller can take. There were also restrictions requiring millers to provide small amounts of grain to poor people at the same rates that they sold wholesale grain to larger families. And the interest in retail sale is also something that many people have assumed to be the result of a modern 20th century mentality when we access so many things as consumer-facing retail-sized products. Another old regulatory tool that takes on new life is the assize of bread, and I have to give a shout out to Bob Gordon there for telling me how to pronounce that word. Originally, the assize of bread developed in medieval England as a way to set the price of loaves of bread indirectly based on the weight. It was strictly speaking, it was a restriction, a standardization of the size of a loaf of bread that would vary with the price of wheat. And you can see a chart of the assize of bread from Salem, Massachusetts there. So in 1692, in response to the regime change in England from the Glorious Revolution, the colony found itself on a new legal footing and had to enact its own assize of bread, which was then periodically revised throughout the 18th century. And the tendency among historians has been to treat this as sort of a medieval hangover and a kind of just price regulation that would eventually wither away in the 19th century. But actually, they, from what I can tell, they seem to get more aggressive about enforcing and publicizing it over the course of the 18th century. And they also moved away from trying to strictly set the price of bread and into focusing on ways to improve its quality. They required millers to sift out rocks from the grain, for example. In statutory law, again and again, it seems like you wouldn't have to ask, but they were more and more serious about ensuring a good supply of high quality bread than just mechanically setting the price as time went on for kind of technical reasons that I can explain more later if you'd like. But all of these laws were primarily enforced by giving anyone who discovered a violation the right to bring a lawsuit and collect a statutory penalty against the infringer. We think of this as being qui tam. If you're a modern attorney, the False Claims Act comes to mind. That's kind of the federal survival of this, but I think a more appropriate term for them would be an informer's action. Sometimes they're called a popular action because any person can bring it. Along with regimes of inspectors appointed by the colony to go around from bakery to bakery, making sure that these rules were being enforced. And so, interestingly, you have a regime with state inspectors and regulators at the margins and private litigants largely driving the law, similar to what we have today, but for very different reasons. Now, I think some of the innovation and the modernity in these regulations comes out in the second category, which is barrels, or as I like to call them, the plastic baggie of the 18th century. People thought a lot about barrels because all of the colonies' economies were based on the long-distance transport of commodities. And fish in barrels traveling on the open ocean for 3 months can get a little gross. And as you read through the preambles of some of these statutes, they go on and on about the great scandal of the pickled mackerel of 1695 and these horrifying events where, if you look behind the curtain a little bit, you have a scenario that modern scholars of trademarks refer to as the experienced goods problem. These are things that a consumer can only assess the quality of by actually sampling them. And so when you get a barrel coming up on board in London or even in Spain, where a lot of the fish produced in New England went, there's really no way to figure out how good it is until you get in there and dig around in the fish. And if you're a fisherman who's had a very bad yield of fish, or your fish have been sitting in your warehouse for a long time, you have every incentive to put those bad fish at the bottom of the barrel and leave the people across the ocean holding the bag. And the result of that is that the price of fish falls across the board, because foreign consumers are not going to pay the same price for Massachusetts fish if there's a risk that a large part of the haul will be bad. Now, this doesn't really sound like consumer protection at first glance. It sounds like a scheme to prop up the prices of export commodities, which it was. But when you began to read the preambles and you look at the newspaper accounts and the legislative journals explaining these laws, it's clear that they were actually being conceptualized as a way to protect consumers in other parts of the British Empire and in the key export markets that New England depended on, especially Catholic Europe, for the provision of fish during Lent. And as time went on, they began to expect the same standardization and consumer-facing treatment from other jurisdictions. This is what is really interesting, and I think separates the Assize laws in 18th century New England from what had gone before. Over time, the inspection and quality standards that were originally intended to apply only to export goods are legally applied by statute to all goods that are being sold for public consumption in the colony. Whether they're coming from New York, whether they're coming from other parts of Massachusetts, the colony begins to both standardize weights and measures according to the English barrel system. And if there's one thing you take away from this presentation, I did learn that a butt load is an actual unit of measurement. It refers to a butt cask. So that's a fun fact you can take away. And in addition to standardizing measures just to prevent fraud, underweight packing, a system of early trademarks, or more strictly speaking, certification marks, emerged, where inspectors would by statute, inspectors were given the right to go and look at all of the produce on the docks, and they would stamp it with the colony seal. So if you've bought a piece of meat in the marketplace saying USDA Prime, that is the descendant of these kind of early certification mark measures. Again, these have a longer history in Europe. They're developed in the Middle Ages, and especially in the Netherlands for the cloth trade, but the variety of goods to which they come to be applied in the 18th century is ever expanding and ever more domestic. For example, things like bricks and cords of firewood, which were almost certainly not being sent away for use in other colonies, came to have these kinds of quality restrictions on them that had originally been associated only with, for example, cod for use in export markets. So the idea of consumer-facing quality standards set by statute and enforced largely by private suits becomes very entrenched by the time of the American Revolution. Those laws remain on the books in the early Republic and well into the 19th century. And in fact, they get more strict and complex as time goes on. Finally, and this is, I think, a more complex but equally interesting category, is borrowing. And I really comprehend a range of financial instruments in that. There's been some great recent work by Claire Priest and others showing how innovative some of the colonies in British America were in creating new requirements for mortgage recording, for example. And the impact of that on property law has been looked at quite extensively. But I think that these laws also show an interesting attempt to turn credit into a commodity in a way that is both that's often thought of as a means of stripping away traditional protections that debtors had, because in an economy where credit is largely personal, you can negotiate with your creditor, you can use informal means to avoid paying, and the assumption in a lot of the scholarship on early America has been that part of the transition to capitalism was turning credit into a commodity that allowed loans to be collected more ruthlessly and efficiently. I'm not saying that's not true, but I think the flip side of that coin is that for credit to work, borrowers have to be willing to enter into these kinds of financial agreements. And the procedural laws that are passed for financial instruments in the colonial period try to do this in a surprising array of ways. So, for example, the colony had a court system that allowed the parties to engage in a de novo appeal at every level. And the filing fees for an appeal were set at like strikingly low rates. The colonial governors complained about this all the time because it was stirring up so much litigation. And that's puzzled legal scholars in Massachusetts, but I found some assembly records and newspaper exchanges suggesting that the real purpose for this was to allow local creditors to delay paying in their debts, because instead of actually paying the cost of litigating at the trial level, they would just have a default judgment entered against them and pay an attorney a very small fee to go and enter in an appeal. And by the time they'd exhausted their appeals, maybe a year or more had elapsed, and they could hopefully collect the debt. And what's interesting is that this wasn't formally a tool to protect debtors, but that seems to be the reason that the court system was designed that way and remained that way. And more strict and direct measures were also implemented. So in addition to when the colony required mortgages to be recorded, which as I understand it was one of the first mortgage recording laws in the world, they also required the creditor to record any payments toward the mortgage on the back of the document. And if the creditor failed to do that, then the debtor could recover any false charges with treble damages. That's also treble damages being a characteristic penalty in modern consumer protection law as well. There were also many bankruptcy laws that the colony passed that were continually vetoed by the authorities in London, probably because many of the creditors were in London and many of the colonists were domestic consumers there in Massachusetts. But even when those laws didn't go through, the colony found other ways to give relief to debtors. One of the most interesting ones was by creating a right of action for a creditor who tried to make a false charge of a debt on a debtor who had been imprisoned for the debt. So in other words, your creditor has insisted that you be put in prison while you pay the debt, and they've had access to the records and they've cooked the books. If you can prove that, then you're entitled to bring an action where you could get quadruple whatever the charge had been brought against you. So to briefly sum all of this up, why should we care about these kind of neglected statutory measures? I think you see a lot of old tools that are easy to pass over, but they're finding new applications during the colonial period, and the traditional ways of regulating through guilds are being passed over in favor of positive law that actually bears a striking resemblance to some of our contemporary forms of economic regulation. And the conceptualization of the consumer in these contexts has often been missed because the regulators of the early modern Atlantic world weren't thinking in national terms. They were thinking in imperial terms, which is exactly what you would expect. But that doesn't mean that they weren't trying to protect classic consumers as they understood it. And finally, I think this has some resonance in contemporary legal debates about standing, where the original understanding of American legal culture in the 18th century has been put into issue by doctrinal developments. We can talk more about that in the Q&A if you're interested. But thank you for listening, and I look forward to it.
Okay, I think this is up. Thank you so much for the organizers for including this paper by Becky and me on the program. I think we're sort of an odd couple out. This paper doesn't connect really with very much else that's on the program, but it does connect with the administrative state. As I mentioned, this project is joint with Becky Eisenberg, and she's a patent law specialist, and I've done a lot of work on patents, but I never studied the patent office or its procedures. And this project came about because of the spotlight that's currently being shown on administrative agencies by the Supreme Court Under the theory of the unitary executive, the court's been undermining Congress's power to design independent agencies that are insulated from presidential control. And Becky had written an article about this with another law school colleague, Nina Mendelsohn, that challenged this doctrine on several grounds, including its historical underpinnings. And much of that paper focused on the Patent Office because one of the recent decisions of the court, which was U.S. v. Arthrex, really sort of imposed this unitary executive theory on the Patent Office, and essentially said that the judges for a current patent court were really not appropriately appointed under Article 3. Anyway, I don't want to go into that decision or the details of Becky and Nina's paper, but I just want to say it got us talking about the Patent Office because they were arguing the court didn't understand the history of the Patent Office. Well, in fact, there's very little appropriate history that's ever been written. And so we decided to start looking at the history of the Patent Office, and particularly focusing on what are called interference procedures. So let me just say what those are. So interference procedures are cases that come up where two or more applications for patents, or sometimes an application in a recently issued patent, make claims for essentially the same technological innovations. And the Patent Office then had to decide which of these conflicting applications should get the patent right. And the standard in US law until 2011 was the first and true inventor. So they set up a procedure to establish priority, to establish who was the first and true inventor. So in looking at this patent adjudication, interference adjudication, we're interested in the more general question of how proceedings in administrative agencies are different from courts. Why you would want administrative adjudication rather than courts. And so we take inspiration from the literature on the theory of the firm. And in particular, Ronald Coase, as many of you know, famously asked, why does so much economic activity occur inside firms rather than in the market? And the answer he gave was that, well, firms had all this flexibility internally to structure transactions in a way that could mitigate opportunism in a way that contracts could not. And so we're essentially asking an analogous question, right? Why does so much adjudication occur in administrative agencies rather than in courts? And the answer that, or really I would say our hypothesis at this stage, is that administrative adjudication mitigates opportunism in much the same way as firms mitigate opportunism. And then the other thing we're interested in, we're interested in learning in these administrative agencies. And so we're exploring the possibility that administrative agencies like firms are sites of learning. And that as a result of the learning that goes on in them, the advantages that they have over courts can widen over time. Now, of course, there are important differences between firms and administrative agencies, not the least of which is that firms are subject to competitive pressures that can cause them to fail, right? And so they strive to prevent that. They strive to improve efficiency. They strive to improve quality. But we argue that bureaucrats also face pressures from the external environment that force them to strive to improve on essentially those same dimensions. And these pressures became intense in the second half of the 19th century as the number of patent applications increased dramatically. And of course, as patent applications increased, patent applications and interference increased as well. Now, no one knows how many interferences there were in this period. there's like 10,000 boxes of this stuff in the National Archives, but we don't know how many there were. The archives doesn't know how many there are. The Patent Office didn't start reporting this until 1912. So our best guess is that the number of interferences rose from about 500 a year in the 1870s and early 1880s to something like 1,500 per year in the early 20th century when we have the first official numbers. Now, even with this growth, the number of interferences is small relative to the number of patent applications. It's about 2% of applications, maybe 4%, 5% of patents. But they were very time-consuming for the Patent Office to deal with. So the main job of the Patent Office is to take these, tens of thousands of applications and see which ones should get patents. And interference, and they're under tremendous pressure to do this expeditiously, and interferences took patent examiners away from this main task. And so under this kind of time pressure, the Patent Office innovates in a number of ways. So first in the 1850s, it reorganized the office to handle these kinds of cases, so that previously interferences had been declared and adjudicated by the same examiners that were deciding on these patents. But by the 1850s, they're realizing they can't do that, and they reorganized the office so that the examiner still issues a declaration of interference, but the adjudication is now handled by a specialist known as an examiner of interferences. And then in 1870, you get a much more spectacular innovation that really sort of, we think, underscores the difference between administrative agencies and courts, and dramatically reduces the number of these interferences that are ever going to have to go the full route to a hearing. Okay, so just show, we only have good data for the beginning in 1912, but all the sort of textual data that we have from before 1870s suggests that these things were just fully adjudicated with evidence and hearings. But after this spectacular innovation, I'll tell you about it a moment ago, 80% of the cases are settled without ever going through, even collecting testimony, let alone going to the full hearing stage. Okay, so I want to use my time to talk about this innovation, and then I'm going to I'm going to suggest it yield efficiency gains that would never have been possible for a court, and then point out that there are still a bunch of quality fairness issues that they're struggling with. Those were much more difficult to resolve, but they would have been difficult for a court to resolve as well. All right, so this key innovation came in the wake of this tremendous growth in applications that follows the Civil War. And it was the brainchild of a man, a commissioner of patents named Samuel Sparks Fisher. He wasn't commissioner very long. It didn't pay well enough. But he had a major effect on the operations of the office. He was already an important patent attorney when he was tapped by Grant to be patent commissioner. And he came with a sense of how the patent office could be improved, and he was just a whirlwind of energy. So one of the things he did was actually to institute an examination system for examiners. They had to pass tests to be hired. And this is he does this in 1869. That's a decade and a half before the Pendleton Act brings civil service reform to the U.S. government. But at that time, he's hiring entirely by examination. And he worked with Congress he did a bunch of things. He worked with Congress to draft the Patent Act of 1870, and that gave the patent commissioner formal authority to write rules for the operation of the patent office. So here's the provision. They did it sort of without formal power beforehand, but now they really have the authority. And he uses this authority to promulgate an important new procedure for handling interferences. Now, there's a lot of text there. This is a key rule. this is his stunning innovation, so I want to highlight the things that are really important. So the first thing that happens is that now, after this rule, immediately following the announcement that there's an interference, each of the parties to the interference has to submit a statement under oath that contains all the important dates that will establish priority of invention, like when they came up with the idea and so on. Now, the important thing about this is that it's done in secrecy, okay? So patent applications were secret, right? Patents are public records, but patent applications are secret. And so what Commissioner Fisher did is leverage that security so that people had to file these statements that established their dates when they came up with things in ignorance of what the other parties had done. And at first, even in ignorance of who the other parties were. And then once the statements were submitted, or the deadline passed, so they couldn't be submitted, then there would be this big reveal, and everyone would see. And sometimes things were really just settled right then and there. Now, I'll say some more about that in a minute, but he's really trying to prevent opportunism here. He comes in and says, you know, before, when people knew who they were and knew what dates people were going to claim in these hearings, they would just make it up, right? And he says, we're going to stop doing this. He says this in a later case. He explains his motivation. And so the idea is to constrain the party. So he has to submit the dates, and then if he changes his mind, that's not going to be believed. Okay, that's not something you can do. And so what happened as a result of this is it was just improved the efficiency of the process. Lots of interferences are just settled then and there. Sometimes another party didn't submit a statement, so then it was just on the date the only date that person could claim was his or her application date. Sometimes the statements were deposited. They made it clear that one person was the first and true inventor. And sometimes they even showed that an inventor did not have any did not have any right to claim invention because it had been in use too long or something like that. Now, the records that we have, now we've collected a lot of records from the National Archives that look kind of like this. These are, there's a docket that says everything that went on in the case, and you can just look at that docket and see how complicated the case was. And you can see that this worked exactly, in this case, it worked exactly like Commissioner Fisher said it would. There's a declaration, then the statements come in, and it's clear that the statements are dispositive, so the Patent Office tells the person who's not going to win to show cause why they shouldn't just award the patent to the other person. And then when that time is expired, they just award the patent and award the priority, and then the guy gets the patent shortly thereafter. So if we graph what we took a sample of about 400 of these from the National Archives, and you can see that what happens is that most of these cases get settled very, very quickly. This is a graph of the number of lines in the docket, which is a proxy for the quickness of settlement, and you can see that they're just settled very, very quickly. And then when we look at our data matches the data that we have from the Patent Office, which suggests about, that 80% of them are settled before a hearing. All right, so this table also shows something else that I think is really important. It shows that the number of lines so you have this fundamental innovation, and you have all these things being settled without a hearing, but the number of lines in the docket is getting longer over time. So this is a major efficiency-enhancing innovation, but it's not solving everything. And in particular, one of the things that's happening is you're getting inventors filing, or their attorneys filing motions to dissolve and other kinds of motions that are saying, wait, it wasn't fair. This interference wasn't fair. These patents are really not an interference, or this other person really can't claim this invention. It's not supported by his or her patent. And so what you find is if you get those motions in the file, the lines get longer and longer and longer. If you don't have such a motion in the file, then it's, there's like 10 lines in the docket or something like that. But then they can get really very long. And let me give you a horrendous example. This is an interference. There's a motion early on to dissolve the interference. Then there's decisions and motions and appeals and all kinds of stuff. And that at some point, the Patent Office issues a redeclaration that reforms that there was something wrong, and they fix it. So there's more statements, motions to dissolve, and so on. And then ultimately, it's decided in favor of the party who was going to win from the very beginning. There's no more evidence that's presented in this beyond the initial statements. There's no testimony, there's no hearings, but this goes on and on and on. And so people began to think, well, these motions were just awful. They were just destroying the whole process. They were costing people a lot of money. They were mainly done with the aim of delaying the whole process. And so there was a lot of discontent about that. And the Patent Office had to figure out how to handle them because, in fact, these motions really mattered. There was unfairness. Something like a quarter of these cases where you get these motions end up with the interference being dissolved, or partially dissolved. Even more were partially dissolved. Okay, so I'm going to finish up, but basically the Patent Office has to figure out how to handle it. It's not easy because in the course of doing this, there's all kinds of things that cause delays, including the appeals process. And so they try really hard to come up with ways to limit the disruptive effects of these motions. And they do things that courts would have difficulty doing. They change who gets to adjudicate them. They cut steps out of the appeals process. They place time limits on when they could be made. This all helps to some extent, but there's a basic thing, like an administrative agency can really make changes that improve efficiency, but when it comes to fairness things, they run into some of the same problems that courts have, and it's very difficult to distinguish opportunism from legitimate grievances. So my conclusions: the Patent Office was able significantly to improve the efficiency with which it adjudicated patent interferences using techniques like leveraging secrecy that would not have been available to the courts, but they still had this problem of fairness. But the bottom line that I want to underscore is that we're talking about a very small number of cases. So only 20% of cases go to hearings. Of the ones that don't, only a very small percent are long delayed. And all the complaints are about these bad cases. And so that's what Congress is hearing, that's what the public is hearing, and that's what's generating ideas about the Patent Office. And that's a bad way to do policy, right? And this is basically the story of the administrative state and the attacks on the administrative state. And what we've tried to do with this case is show how much actually gets resolved really quickly, really efficiently, really nicely, but that's silent, right? And we need to uncover those silences to really understand the administrative state.
be here to talk with you guys today about this project. This is truly a working paper. I think I've changed the title 5 times and rewritten the introduction 6. But it's particularly an exciting one for me to work on and present to you guys here today because I've been thinking about it as something that would press you to the next book project. So it's something of an intellectual scaffolding, the doctrinal scaffolding of where I hope my next book project goes. So I'm really excited to share the ideas. All right, so so I was recently invited to contribute a paper to a symposium with the Journal of Antitrust Enforcement on antitrust law in service of democracy. And of course, this has been motivated by this growing sense of economic and political crisis today, characterized by rising economic concentration, though that is contested by some scholars, falling labor share value, and the increased dominance of a handful of digital platforms. And these issues, of course, raise key questions, many of which require us to think about a longer term rather than shorter term considerations that economics has often pushed us towards. So those include the effects of productivity and innovation, given those crises of today, democratic accountability of firms, the power of workers, particularly in markets characterized by monopsony, and the political influence of large-scale firms on the democratic process. But for me, as an historian, this presented 2 main challenges. The first was, this is already a crowded field with some really excellent scholarly work by antitrust scholars. But much of that work is really prospective, right? It begins with a normative framework and then assigns procedural fixes to achieve or to approach what the law should be doing. These papers, they argue for changes to the law or to the institutional structure of the law of antitrust to enhance democratic participation or responsiveness to democratic demands. And as a historian, so this is the second point, as a historian, I wanted to try to avoid this pull of the present in order to more fully explore the historical contingency that shaped distinct eras of antitrust law in order to better understand how and why antitrust law has developed as it has in this post-World War II time period. So with this framing in mind, I set out to historicize the idea of market power since World War II and to explain how contests over the meaning of market power have shaped the direction of antitrust law. So I should pause and note for the uninitiated, in antitrust law, we have basically 2 categories. We have illegal per se, which is the categorical prohibition of stuff we don't like. We don't need evidence of market power. We don't need to argue about any potential pro-competitive effects of price fixing or bid rigging. Prohibited categorically. But the vast majority of the interesting stuff in antitrust falls under this rule of reason, where market power is always an important consideration. It's often a first step consideration, wherein we want to ask if the firm or firms have the ability to actually effectuate some anti-competitive scheme, right? Okay, so I argue that as a historical matter, antitrust law is not solely a story of the refinement of economic ideas over time. So this is what am I pushing back against? In other words, this is not a movement from uneconomic antitrust law in the immediate post-World War II time period to then the discovery of price theory and transaction cost economics then thereafter. Neither do I think that this should really be understood as a regulatory pendulum that just swings back and forth. The question is, why are certain economic ideas salient at particular moments in time, and how does that come about? Antitrust doctrine, especially in the post-World War II time period, is largely judge-made law. And it has responded to the contests over the meanings of market power that have emerged from a larger social scientific community of lawyers, economists, even some historians, and policymakers. And that community, I argue in this paper, has responded to real-world problems and pressures that have arisen at particular moments in time in US political economy and in the world. Okay, so now I'm not sure that this necessarily gives meaningful democratic content in a participatory sense to antitrust law, but perhaps it situates antitrust law within the demos such that we may evaluate not only why the law has taken its present form, but also where it should go next, and how to make those changes durable. So in this paper, I focus on the issue of exclusion, which is a core antitrust concern. Since at least the 1950s, at times, the courts have used the terms market power and monopoly power interchangeably. And the Supreme Court has defined both as the power to control prices or exclude competition. Now, exclusion can be a Section 2 anti-monopolization claim, unilateral effort by a firm, or it can be a Section 1 claim of collusion, right, what we think of as cartelization cases. Exclusion, for example, takes a couple of forms, characterized here by raising rivals' costs, excluding competitors from the market that, but for some action, some exercise of market power, would be participating in the market. So raising rivals' costs by, for example, denying access to a critical input or denying access to a critical infrastructure. Raising rivals' costs by exclusionary contracts with their perhaps distributors or retailers, which denies access to distribution networks. So I focus on exclusion because it's provided perhaps the most important ground of contestation across various schools of thought. And as we reflect on the democratic content of antitrust law, we may note that this exclusion element of the exercise of market power comes in direct conflict with the egalitarian promises of democratic capitalism, namely protecting a decentralized economic system that empowers entrepreneurs and workers, that protects access to markets, and that may drive innovation. So here's my periodization that I'll discuss for the rest of my time. The paper is divided into 3 sections that follows the rough periodization that most antitrust scholars, I think, would agree with. It begins with this high tide of antitrust enforcement beginning in 1945 and moving through the early 1970s. This is the height of democratic capitalism and the height of democratic capitalism for antitrust law. In response to the Great Depression and World War II, the US reoriented democratic capitalism through institutional and legal changes. It was characterized by Keynesian demand management and complemented by powerful unions, a robust regulatory state, and increasingly large-scale firms. This was a boom time for manufacturers, especially in the United States, which were driven to achieve economies of scale, often through Fordist methods of mass production. So I begin my paper with a short exposition on democratic capitalism after the war and the case of US versus Alcoa, which is decided in 1945. This sets the stage for post-World War II antitrust law, and it prohibits exclusion by way of producing ahead of demand and monopolizing hydropower inputs that are necessary for the production of aluminum, which is very electricity intensive. It also prohibits exclusion by way of collusion through an international aluminum cartel as well. All of this also reflected the economic knowledge of the time. The Harvard School of Industrial Organization dominated the landscape at this moment. And it was controlled by this concern, or I could say animated by this concern about industry concentration, about the structure of an industry itself, necessarily leading to anti-competitive conduct and thereby poor economic performance. This is characterized by Joe Bain in his work in structuralism in industrial organization. So he creates the structure, conduct, performance test in antitrust law. The insight was that if an industry could be found to be highly concentrated, then anti-competitive conduct, pretty much, necessarily flowed from that industry structure. And you can see the way in which that structuralism influences antitrust doctrine in the immediate post-war period. what we see is the development of really strict rules and an expansive set of the category of illegal per se. We see active deconcentration efforts through merger and acquisition enforcement. And then third, the result is that, outside of doctrine, firms could grow large. They did grow large, but through internal expansion as opposed to through mergers and acquisitions, much like what the new merger guidelines suggest is preferred today. But beginning in the early 1970s, a discernible shift begins to take place in antitrust law and economics, particularly regarding the meaning of market power. And it sort of overtakes the structure, conduct, performance paradigm. So in the paper, I argue that it was this combination of several factors that pushed this reconsideration of market power. Those factors included this shock of declining US competitiveness as European and Japanese producers came back online, rising and fluctuating inflation, which was also exported under the Bretton Woods system, and then also this creeping distrust of government, which comes from the left, characterized, as Jared set me up for, Ralph Nader's reports in 1969, and then also on the right as well. But rather than focus solely on the Chicago school here, which is characteristic of the literature, generally, this section borrows from newer scholarship that emphasizes what Bill Kovacic has referred to as the, quote, double helix of Chicago and a reformed Harvard school. So Chicago law and economics shifted presumptions to bolster the idea and the desirability to achieve economic efficiency. And this idea of economic efficiency as flowing from large-scale firms. In other words, nothing to fear. But also about the resiliency of the market itself, right? The potential competitor lurking behind every corner, in other words. Harvard scholars accepted much of this. I'm thinking about Donald Turner, Philip Arita. But they also had their own points of emphasis and desires for reform. Harvard scholars emphasized the necessity of administrable rules and accepted much of the error cost analysis that was coming out of Chicago scholars and is characterized by some of Frank Easterbrook's writing. So when the Supreme Court intervenes to shift antitrust law, it's not simply Richard Posner and George Stigler who are being cited, it's also Arita and Turner. This led to this confluence of the means considered appropriate for intervention as being dramatically scaled back. Market power remained an important first step in antitrust analysis, just as it is today. But now the market was bigger, and all the firms within it looked much smaller. The new emphasis then was not on finding market power and assuming that anti-competitive conduct flows from it, but rather the new emphasis was interrogating the conduct itself and looking for some business justification. Judges were increasingly reticent to intervene, in part for fear, as the Harvard scholars emphasized, of the dreaded false positive, right? The type 1 error, which they had argued, many people had argued and they had accepted, would be so difficult to overturn. In case law, we see this movement in stark terms. Directly after Nader's 1969 report and the ABA's reports, we see this decline of Robinson-Patman suits, especially those brought by the FTC. We see the overhaul of antitrust doctrine, and particularly as with regards to predatory pricing suits. Most notably in Matsushita versus Zenith Radio. That case was decided in 1986, but it had 20 years of winding through the courts before. We also see this dramatic doctrinal shift in vertical restraints cases as well. So types of contracts through the distribution chain that can exclude competitors. You can only deal with me to sell these TV sets, etc. So those are now legal. So we're still, right now I'm in the third period here, we're still living in this double helix of antitrust law, but it's increasingly referred to as ossified, petrified, etc. And it's ossified Chicago law and economics. And what this means is that it's sort of failing by its own standards. There's this looming crisis precipitated by cases like Trinco and Ohio versus American Express. And additionally, in the 21st century, we have seen market power coming back into focus as a problem fit for remedial action by courts or by parties. Since the Great Recession, there has been renewed concern with this relationship between rising economic concentration and the erosion of political democracy. This feels anathema to antitrust rules in language because it has dropped out of usage for decades. But it is the crux of the critique, and it plays out in several ways. Market concentration has translated into undue political influence over political processes, and it has hampered entrepreneurial innovation by erecting barriers to entry through exclusive contracts and technological ties. For example, in the Microsoft 2001 case, and the more recent US versus Google search case. What these end up doing is raising, these are tactics by which firms can use exclusion to raise the minimum efficient scale that is necessary just to enter into a market to start to compete. And then plus, we have this labor market power, which has hampered real wage growth and contributed to a loss of autonomy. For the first time, perhaps ever, antitrust law is now being leveraged by laborers to bring suit against labor market power. And social science research has provided the scaffolding for these critiques, both of market concentration and of existing law, again, failing by its own standards. So I want to emphasize that it cannot be dismissed in this current moment as simply populist. That's my point. Macroeconomics has discarded some of the presumptions and theories of Chicago law and economics, for example, the plausibility of predation, and it's given renewed attention to inequality. Microeconomics, borrowing from the post-Chicago school subset of behavioral economics and game theory, has returned to IO to rethink how market power can be translated or leveraged into adjacent markets. And these inquiries are critical to understanding how platform economies respond to different incentives, right? Indirect network effects, and can produce harms which we are already familiar with. Exclusion from the market. So I'll just conclude very briefly with 3 points. This work explains why antitrust law seems to have focused more on collusion as of late and hardcore cartels to the detriment of exclusion cases in the more recent times. And it seeks to revive exclusion as a core antitrust concern. Secondly, this work puts antitrust law in context of larger macroeconomic concerns, which helps explain when and why liberal technocrats joined with their more conservative counterparts and how this double helix of reforms got away from them or ossified. Third and finally for today, it seems imperative to continue work on explicating these problems, new and old, of market power. And indeed, much of this work is already underway. Thank you.
Okay, so it was a pleasure to get a chance to read and think about 3 very interesting, although I must say very different papers. So I'm tempted to take Greg's, what was the line, take my comments with a grain of salt. I was learning a lot as I was reading here, but I'm happy to discuss more. So the usual assignment of the commentator is to indicate through lines that connect the papers. This is a tough challenge here. I'll just kind of throw out one that struck me, I think especially with, I'm going to go with first names if that's okay, if it's easier. Laura and Jared's paper, which focus in different ways on the problem of historicizing a concept or term. So Laura shows us that from the Second World War through the present, courts, economists, commentators all agree that the concept of market power is central to antitrust law, but even though they're all talking about market power, it turns out that they're talking about different things in different moments of time, shaped by different ideas about the proper relationship between markets and democratic society. In contrast, Jared's study of colonial Massachusetts demonstrates really considerable continuity in core ideas of consumer protection through time, even though the term as such, arises at a much later moment. Naomi and Rebecca do not kind of similarly trace a concept or term through time, but their paper does, to my mind, raise the question of, are there, missing concepts or terms that are kind of lurking in the background? They spent a lot of time thinking about the administrative procedures historically used in these patent office interference cases. I found myself thinking about the concept of administrative procedure as a category and historicizing that and the role that's playing in the background. Okay, so a few questions for each of the papers separately. The order here is purely the order in which I happen to read them. There is no deeper logic. Laura offers this really fascinating intellectual history we just heard, an account of the evolution of antitrust doctrine from the Second World War onward. And I thought one of the most interesting interventions is to challenge the received wisdom that, what was taught to me as the Borkian revolution in antitrust, that was kind of exclusively coming out of Chicago School of Law and Economics, in fact emerged, as a part of a broader shift in ideas of antitrust that included more left-leaning types at Harvard. And this, the main question I had really had to do about the nature of the claim you're making about social science and its relationship to some conception of democracy or the democratic. And I think I kind of noted as in the oral version, you had this kind of comment about, I'm not sure this gives meaningful democratic content. And of course, that's kind of my core question. How are we using democracy here? But the thrust of the argument seems to be we need to take social science seriously. It exerts influence in ways that cannot be reduced in any simplistic way, including to kind of ideas about the powerful capturing thought. I mean, there's this whole literature on kind of the conservative legal movement and how it kind of was very consciously financed and helped bring about Chicago Law and Econ. And it's clear, I think you're going after that. You're also, as you say, going after any notion that the evolution of social scientific thought is insulated from context, right? You say, you reject, quote, the idea of a linear refinement of social science. But at the same time, you say social science is connected to, quote, real world economic and political concerns in particular moments in time. Mm-hmm. So, when and how is social science shaped by external forces? Mm-hmm. And to the extent you're going down that route, how are you also arguing it's independent? I mean, where is it independent? Where is it connected? And what are the stakes for you in that argument? I think you began to get at that a bit in the oral presentation, kind of rejecting a populist idea, for example, is pushing forward new ideas in antitrust now, but I'm curious about that. And then in the framing of the piece, the written version, not so much here, you emphasize a kind of argument by Hofstadter that you reject, and you characterize him as arguing that the evolution of antitrust should be understood as a battle between democracy and technocracy, with kind of expert economic technocrats can come in to control the field, and you say no, economics itself reflects shifting ideas about what capitalism and a democracy ought to look like, and so by implication, there's something democratic about social science or something democratic about technocracy. And I started to think of the different ways you might mean that. I mean, in the paper itself, in the first section, the texts you are analyzing are very much judicial texts. And then there's this shift. The second section in the kind of the 70s period is like, now we're talking about economists. We're just reading economists. So, I mean, even in your own version, kind of professionally trained economists seem to dominate. So I assume you're not rejecting that idea, but there's some notion here that that the economics itself, again, is informed by something more democratic. And I'm grappling with how to make sense of all that, but it's very interesting. Okay, paper by Naomi and Rebecca. So really richly detailed kind of institutional account of the evolution of administrative adjudication procedures in the patent office, and in particular in these interference proceedings. As it happens, I have recently spent time trying to find secondary literature that will tell me about what internal administrative procedure looked like in agencies, from the 19th century through the enactment of the Administrative Procedure Act in '46. I can confirm it's rather shocking how little is out there. So just kind of building up our actual knowledge of how these institutions work, I think, is clearly a big contribution. And as you heard, right, the core argument here is that administrative adjudication enables a kind of flexibility in procedural design, and then I think crucially redesign over time that makes it possible for agencies to resolve at least certain kinds of disputes more efficiently. And the written version of the paper seemed a bit stronger on this point, like accurately and more fairly, and that's one of my questions, how far you want to go with that, as compared with courts, preventing kind of parties from opportunistically gaming procedure towards their own ends. And the evidence on kind of efficiency is really quite overwhelming. I mean, it's very persuasive. To my mind, it's kind of a harder question, and as I said, I felt like the claim was softer in the oral presentation. Like, how do we compare courts in terms of questions of accuracy? Finding a baseline there is really hard. Maybe you don't need to do that for your argument, but I wasn't sure how far you were going with that. The bigger question I have is the relationship between your account of the internal development of patent office procedures and kind of the broader backdrop of shifts in the administrative state kind of going on, and debates over the administrative state going on across the period that you're studying. And thinking here in particular of the concerted effort by parts of the organized bar to undermine the modern administrative state in the early decades of the 20th century. The bar is, of course, divided, right? The kind of rising corporate bar is, sympathetic in many ways to the administrative state, but, important parts of the bar, litigators in particular, are not necessarily so sympathetic. They view it as a threat to their traditional court-based authority. And I'm thinking here of Daniel Ernst's written recent book where he talks about how this kind of battle with lawyers, or a segment of the bar attacking the administrative state, plays out in part as a dispute over internal agency procedures. And right, his bottom line is that lawyers basically succeed in importing core aspects of common law adversarial procedure into the administrative state that then gets eventually codified in the APA. And of course, a lot of what we think about with administrative procedure is different than your case, because we're, with the kind of classical case we're worried about is the state, prosecuting a private party, and you have this interesting case here of two private parties. But even so, I would imagine that the Patent Office would have been kind of thinking about and worried about kind of the broader backdrop of, kind of how administrative procedures are being shaped across other agencies in a moment of pushback from lawyers. And I'm wondering, how they're reflecting on that context. You didn't talk about this in the oral presentation, but the paper ends with this effort of the American Bar Association in 1944 to take patent interference cases out of the Patent Office and have them adjudicated in courts. I couldn't help but wonder, is that effort part of this kind of, attack by lawyers? And then, Jared, as you know, I think this is such a wonderfully ambitious and creative project. I really find it really fascinating. You draw together scholarly literature on the rise of consumer society with this kind of, as you noted, kind of older literature that thinks about economic regulation as necessarily backward-looking and mercantilist in this colonial period, and you kind of reconfigure it and show us how maybe the stuff we viewed as, old-fashioned and outdated is actually serving these modern goals of consumer protection, right? Both consumer welfare and growing the economy. So you raise, a lot of the obvious. I mean, this paper is so wonderfully ambitious that it raises, it scopes out a whole other area to pursue. So obviously, it raises a lot, and you noted yourself what how does colonial Massachusetts compare to other places? What does the law look like in action? One question that I didn't see you raise that I would love to know more about is who precisely is the consumer? As the paper is written, there's an almost a feel of a kind of consumer in the abstract, a universal consumer, without that many kind of defining identity features, right? Everyone is upset if the fish is, smelly and awful. That's a universal. But there's a substantial literature, as you know, on the rise of consumer society that's linked to the growth in a market of consumer goods for women in particular. Clothes, fans, etc. These are very different kinds of goods than the mostly foodstuffs, in which at least 2/3 of your piece focus. They're much more readily associated with the critique of luxury, with the critique of markets. I also thinking of Laura Edwards' recent book that doesn't go back as far as you do, but goes back to the American Revolution and suggests again that kind of goods we associate with women, textiles in particular, are subject to their own very different legal economic regime. Anyway, so I'm wondering about different forms of identity the consumers may have and how the law is regulating them, women in particular, but we can imagine other categories of consumer. I would love to know more about the relationship between your study and political economic thought in the period, right? There's all the law and action questions you raise that are yet to be decided, but the intellectual history kind of angle, how this intersects with that literature. And then I've said this to you before, I'm still very curious about the through line moving forward into the present, or at least into the 19th century. You kind of frame the analysis vis-a-vis Bill Novak and the well-regulated society, suggesting that there is a direct through line. You do note in the piece that the size of bread in Massachusetts itself is abolished in 1797. That timing would seem to fit with the more usual story of a sharper break between an older mercantilist economy and a modern one. I take it that's not the case, but I'd like to understand why that's not the case, especially because that's also the period where one would expect physiocratic thought, which I understand was read, and people like Quenet and Marivaux were read by the founding era leaders. We're arguing that deregulation, right, of the bread trade was actually essential to growing the economy and to consumer welfare. So I'd like to know not just about continuities into the present, but also ruptures. So please have at it, Spencer.
Thank you all three for such wonderful papers. I want to ask Jared, building off Professor Kessler's questions about sort of who is the consumer, and is the consumer the same person as people who consume? And is there something about a certain level of participation in the market, however we define that? Because I was really interested by you bringing in the size of bread under the rubric of, say, consumer protection, rather than or in addition to a charitable measure or a measure of kind of moral economy, to put my E.P. Thompson hat on. But it feels like the more what we think of as consumer goods, like cloth or fans or luxury products, you wouldn't be able to do that kind of nexus, because those are not the kinds of goods where the poor are being. It's important that everybody be able to buy a fan is not coming under the same heading as everybody should be able to buy bread. And so what do we do about, is there a different status depending on what you're consuming, whether we think of someone as a consumer? And also, where does public health fit in this? Because you could also see a requirement, well, the fish needs to be pretty good, not just as a nobody wants to buy smelly fish and it'll bring the price down, but people are going to get sick. And there's a long early modern tradition, as you know, of trying to regulate the quality of food for medical or for public health purposes, in addition to a kind of nascent consumer protection. So I'm just interested in your thoughts about how much difference does the kind of good make, and how do we relate consumer protection, poor relief, and public health regulation?
Yeah, these are all excellent questions and ones that I share. I think in the written version of the paper, I'm a little bit more cautious, and it is a distinctive feature of the modern consumer movement to make the move of saying, oh, everybody's a consumer. The consumer interest is everybody's interest. I think John F. Kennedy said that actually in a famous speech in the 60s. So you have to be cautious, certainly. Interestingly, people are using the word consumer in the political economy of the period. So people like Charles Davenant, for example, and other kind of Whig and Tory projectors and political economists are bandying this term about not so much with respect to consumers of luxury items, but to consumers of staple goods that are the foundation of the economy. But textiles actually do come into that equation because they're so important to the balance of trade. And the connection to luxury is very perceptive, and that's something that I need to engage with more, because there's sort of a dual side to consumer protection. In the most basic sense, the goal is to increase consumption, but especially in the early modern period, and I mean even today, consumer protection is also paternalistic in the sense that it's trying to divert people away from certain kinds of consumption. So that's very true in debt regulations. Like the whole idea behind usury law is that certain kinds of credit just shouldn't be available because they're so pernicious and people do such a bad job of evaluating what's going to help them in the long run that we should just eliminate those from the market. And interestingly, usury laws are often in the mouths of contemporaries kind of in the same breath with things like the size of bread and price regulations on corn, the corn law debates in England. So all of these things are kind of going together, and there's no denying that you are beginning to see the later 19th century laissez-faire mentality developing at the end of the 18th century. It shows up in newspaper accounts. What's interesting to me is how out of the mainstream that is. At least part of it's the parameters that I've put. I really have only looked up to materials into like the 1820s and 1830s, and really I'm focused on the 18th century. But the voices that are making this argument that, channeling the physiocrats and Adam Smith, I perceive themselves as these, minority radicals that are doing something really subversive. And so the legislative zeitgeist is totally not there, even after the American Revolution, in theory, shakes off some of these obligations to follow the regulatory schemes that were laid out in Great Britain. A pretty interesting example of that is Thomas Jefferson's model code for the state of Virginia, which includes a lot of laws basically identical to the ones that I discussed about false marking and qualities for wholesome provisions. And the public health angle is very interesting as well. Like that's definitely a longer tradition that's wrapped up in this. And I think there's definitely change, but there isn't the kind of sudden. I would say I think you have to recognize that there is a movement, but there's not like a sudden rupture that some people like to depict, hinging around the American Revolution with this dramatic, vault into unrestricted laissez-faire capitalism.
Oh boy, Greg, Karen, Carolyn, and forgive me again, Austin.
Okay, I'll try to be quick. So this question's for Naomi. As someone who has also waded into the waters of 19th century administrative adjudication, I both really appreciated this project and then had a couple questions about thinking about its implications. So one is, one of the things that struck me in my own research is that into these sort of land claims tribunals or commissions that are deciding these issues, is that in the late 19th century you start to have more of a process of sort of what we might think of as like legalization or even courtification, right? Where you start to have courts as appellate bodies overseeing and as overseeing the way that these administrative adjudications occur. And I don't remember for sure. I remember there are some cases in the late 19th century about the Patent Office and the process of appeals from Patent Office to the federal courts. I don't remember exactly what the provisions were, but I'm curious to what extent the part of the story here is an interaction between courts and administrative agencies that are happening at this particular moment, right? In other words, there is an interplay, particularly around the questions of fairness, where there's this sense that there's some sort of judicially imposed limits on what they can get away with because there's a sense of scrutiny. And then to Amalia's question about efficiency, I think about the comparison of the administrative adjudication of immigration claims that actually Karen has written about that is happening in the same time period, where you have sort of moving many of these immigration claims out of the courts into administrative agencies, effectively as a way to kibosh most of those claims, right? I mean, excluded Chinese litigants had much greater success in front of the courts than they had in front of these administrative agencies, which, I think has a very different, is an increase in efficiency, but has a very different valence in this context. And so, I think putting it in dialogue, that these administrative adjudications with the broader world of late 19th century administrative adjudication helps us think through these categories and the way they were understood at the time.
That's great. I couldn't agree with that last comment more, and part of our sort of large ambition is to be able to think about those issues. As part of making the claim that this is not a one-size-fits-all world, and to talk about a unitary theory or something like that does damage to all agencies is wrong-headed. But not all agencies do things well, right? Or improvements over the courts, and especially on dimensions of fairness. In terms of the interaction between with the Patent Office and the courts, it's really interesting. The Congress sets up appeals processes and then takes them down and things like that. So the Patent Act of 1870 actually made interferences, unlike other patent matters, not appealable to the courts. It was possible, there was another process. You could, the law allowed people who were dissatisfied with the outcome to file a de novo claim in equity, which is not an appeal, right? And it's almost never used. So there's long periods of time where, Congress just says, this is an internal Patent Office matter, it's their discretion, we're not going to set up an appeals process. And then, at some point they set up a different appeals process, but they tinker with it over the whole course of history. On the plane coming over, I was reading a new manuscript by Peter Conti Brown and Sean Vanatta about about supervision, bank supervision. And there's a similar kind of feeling in the late 19th century of Congress that you're just going to allow the control of the currency enormous discretion, and that this is not going to be overseen by the courts. And that's, in a sense, very similar to the discretion that the courts in that period give the Patent Office.
I want to hear everyone's questions, but we have limited time, so can I suggest we collect the three? Is that okay? And everyone will somehow remember? Okay, Karen, go ahead.
Okay, I have a very similar question to Greg for Naomi. So instead I'm going to pitch this to Laura, a subject about which I know less, but I was really taken by the way that you described your project and the way it sort of interrupts. Like, I think the narrative in our minds is this kind of pendulum swings back and forth about what antitrust is actually about, and you're kind of giving it a coherence, which I really like. So I think this is a version of Amalia's question about the money behind the knowledge in some ways. So are you coming out of this, do you think, with a position on who should get to define what market power means, or will part of this project even be kind of descriptively about how does somebody come and occupy that space in a given area, and then how do they get pushed out?
And Carolyn?
Excuse me, I had a question for Jared. I was wondering if you cover in your paper whether or not there was criminal prosecution, either public or private, during the period you're studying. And the reason I ask, is that I think it's kind of an old American legal history chestnut that criminal law professors like to trot out in class when they're explaining regulatory strict liability to say that, the economy is changing. You don't necessarily know whose cow the milk is coming from. So that is why, we need to protect the consumer through regulatory strict liability. But I was wondering, I think it'd be fascinating were you able to prosecute somebody if you choked on a rock that was in your bread because the miller didn't have good quality flour, or if that bad fish gave you ptomaine poisoning or whatever it is that you get from bad fish? Can there be a criminal prosecution, even some kind of strict liability homicide, or something like that? Because that would go against so much thinking in criminal law. I think about the difference between common law and regulatory strict liability, and between the two different types of economies. I'm just curious.
Austin?
Yeah, this is kind of building on Greg's question to Naomi. I'm curious a little bit, you have this tension between sort of this uniquely gifted bureaucrat who makes these shifts and this notion of sort of agency learning. I'm wondering if there's just in this bigger argument about the ways in which agencies can operate with this institutional learning, are there other agencies that you're thinking about that build out this example to make it seem like a broader trend?
Laura, you want to start?
Oh, sure. Yeah, of course. Karen, thank you so much for that question. I think that what I'm trying to do in this paper is complement, in a way, sort of supplement some of the work that's out there that's on corporate capture. Most recently, Lancieri, Eric Posner, and Zingales published a big piece on corporate capture and in antitrust law. And I think that there's a lot correct about that, but I think that it's missing the ways in which consensus gets formed and is shaped by the doctrinal confines of having to find market power in the first place, with lacking statutory intervention, right? So we may see maybe a more European regulatory approach, like what they're doing with the Digital Markets Act, which could maybe get around some of these questions about the money behind the knowledge and then who gets to define what market power is. But so that's going to partially answer, I think.
That's a great question. And in one sense, it's the answer is simple. In another sense, it's complex. It's simple in that these are, with a very few exceptions, all strict liability offenses. They don't care if you did it on purpose. And the whole point of them was to actually enforce regulations that were not concerned with malum in se kinds of actions. So there's a great law that actually was vetoed, but I think is illustrious by the authorities in London about ship making. They make this extremely elaborate code for shipbuilding after they have some disaster at sea where a prominent sea captain is killed, where a justice of the peace is required to appoint a commission of shipbuilders to go and watch anybody making a ship. And if anybody becomes aware that you didn't get the commissioners and you didn't follow all of these extremely detailed rules about what you have to do to the gunnels and the jigs and all of that, then they can proceed against you and bring a claim. So it's very rare to see any knowledge requirement at all. So I think it actually does. Your point is very perceptive because people have looked at the common law for the colonial era sometimes and said, there's it's totally a caveat emptor world. But in reality, there's this architecture of positive law that is very much a strict liability regime. In terms of whether that's a criminal prosecution, that is slightly more complicated because most of these are, if you look in treatises, they would be described as penal statutes, but in the sense of assessing a penalty rather than necessarily constituting a misdemeanor or a felony. So sometimes some of these actions would be brought like in the name of the colony, sort of like in a qui tam structure. Some of them would be brought in the name of a private person, depending on how they were set up. So they're kind of in this weird in-between space of criminal and civil actions, which is another reason why they've been neglected. Like they're hard to understand. But the broader point of what kind of regulatory regime they are, yeah, that's exactly right.
So thank you, Austin. So this is, you put your finger on something that has created a lot of unease in my mind, like what's going on here, how much of this is in the agency itself and the learning process, and then how much is innovation, and by these, sort of remarkable people. And I can't answer this yet, but I can say that it's in some way it's going to be both, but probably the most important thing is this innovation. And when I heard a paper, we're probably not going to study other ones. This is just a patent office study, but I heard a paper by a political scientist. It's a game theoretic model of exactly this problem of when are they able to do things. And it was a model of someone coming in from the outside as in one of these top positions and being the person who's able to catalyze the change. But it was an intriguing model, and maybe that's the story. I don't know.
Well, thank you so much. This is great. Thank you.